You go down, check your attitude, and then I'll call your case back up. Have a seat. Have a seat.
Welcome back to another jaw-dropping courtroom showdown. Today, we're diving into YPF 16 LLC versus Keir Fleming, a case that's about to test patience, financial accountability, and courtroom composure. We've got a landlord pushing hard for nearly $4,300 in unpaid rent, a tenant relying on rental assistance, and a judge who does not tolerate disrespect. Watch closely, because things get heated fast, with tempers flaring, warnings flying, and a ruling that could change everything for Ms. Fleming. Will she find a lifeline, or will this end in eviction? Let's break it all down.
Court calls the case of YPF 16 LLC versus Keir Fleming.
Good afternoon, Your Honor. David Fantier on behalf of the plaintiff.
Your name?
Keir Fleming.
All right. Where are we on this case?
Ms. Fleming has a balance of $4,298.39. She indicates that she mailed the rental assistance form to the court on Wednesday.
She mailed it on Wednesday?
Yeah, I didn't know. I couldn't really hear you, but I thought you said mail it in, so I mailed it in.
Well, it needs to
proof
be at
that
the court by
I filled out an SIR with my tracking number and everything. I mean, an SER.
I don't have it. So.
Well, I sent it in.
Your Honor, I'll leave it up to the court what the court wants to do. I don't think she...
Yeah.
Now here's the kicker. According to the plaintiff, not a single payment has been made by the tenant directly. SOS, the rental assistance program, has been covering the landlord's portion, but that's not a forever solution. This raises the legal issue of tenant responsibility. Was Ms. Fleming relying too heavily on assistance without a plan B? And bigger question for you, should courts be lenient when job loss is involved? Or is rent a hard line that must always be paid? What do you think?
Her balance is $4,298.39. She's been on rapid rehousing with SOS paying their portion. She's never made a payment to my client. And I reached out, and from what she has said, so I reached out to SOS to see if they were going to be able to help her with the balance. What she indicated to me was...
Can I talk? They're not going to be able to help. They're not going to be able to help with balance.
Ma'am. Let him finish, and I will hear from
I don't like.
You want to know what? You don't try to overtalk me, because that will never happen.
That's fine.
Am I understood?
Yes.
You know what? I'm going to pass the matter. You go down, check your attitude, and then I'll call your case back up. Have a seat. Have a seat.
Man, you about to...
Whoa, did you see that? Courtroom patience just hit its limit. Judges expect respect, and backtalk is a fast ticket out the door. This isn't just about tone, it's about credibility. When a defendant shows attitude, it can overshadow their financial hardship and make the judge less sympathetic. Question for the viewers. If you were in Fleming's shoes, would you fight back verbally or stay silent to protect your case?
Piss me off. Come on.
Keep back talking. You better take that out of here. Oh, don't give me that look. Lee, get her out of my courtroom. Get her out of my courtroom. Court will pass that matter. Court does call the case of YPF 16 LLC versus Nakia Turner.
Your Honor, I'll wait for it.
That just messes up my whole day. Everybody else is going to have a hard time with me now. You know, I was in a good mood, and then it's just going to take one person. It just takes one person that just messed up my whole attitude. You know? Nakia Turner. That's you.
Your Honor, I filed an administrative closing on this case. I was able to verify with her bankruptcy attorney that there is a bankruptcy in both their names. Okay. And so I gave to...
and I will sign the order for administrative closing.
Great.
Got it. And YPF 16 versus Christina Morgan. That matter is dismissed on plaintiff's motion without. And so we only have her?
Yes.
Do I want you to go get it? Not really, but I don't want to hold up Mr. Pantera. Tell her she can come back in now. You know, people, if she don't act right, it's gonna get bad. No, hey, I'm just telling you. I'm just giving fair warning.
Would you like your coffee, sir? So we can go get it for you right now.
No, I'm good. I don't know about the rest of you, but I'm good.
We respect you, sir.
Your Honor, if you want to pass.
I'll pass it and then. No, you know what? You keep talking, I'm gonna do something to you too. Court cause of case, so Augusta Woods versus the Geraldine Ballard.
Good afternoon. Good afternoon, Your Honor. David Santa Croce on behalf of Shelby Mink. Oh,
Okay, got it. Is she in the premises or
so
Here.
her
YPF 16 LLC versus Kiera Fleming? Parties have returned. Mr. Pantera, you were in the middle of.
Now that we're back in session, the numbers are clear. Over $4,200 owed plus court costs. Here's the legal nuance. When rental assistance ends, responsibility shifts entirely to the tenant. Programs like SOS are meant to stabilize, not to permanently replace payments. So the court is now evaluating whether Fleming has any realistic path to catch up, or whether the landlord gets a judgment today. High-stakes moment.
Your statement, sir.
Yes, her current balance is $4,123.39. Court costs of $175 for a total of $4298.39. She's been in rapid rehousing where SOS has been paying her portion and she's supposed to pay the rest. She has never made a payment. I reached out to SOS. They tried to reach out to her, and it's my understanding that the rapid rehousing ends at the end of July. So in August, she's gonna be responsible for the whole thing herself. She hasn't filed a rental assistance form. I don't think there's a tribal issue of fact. We would ask the court for a judgment.
Right, ma'am, what did you wish to say?
Anyways, like I was saying, SOS was paying my rent for 3 months without me having to pay anything. Like I told Ms. Terry through SOS that I ended up losing my job, and I wasn't able to pay nothing at the moment, and I'm just now getting a job, and I wasn't able to pay nothing until today. But yeah, and I sent in my SER through the mail. I didn't know I had to come and actually bring it here. I don't have a car, so anytime I go anywhere, I have to get on a bus with my children. So I don't know if you're able to, if they bring the mail to y'all, but I definitely sent the SER to this courtroom with the judge with your name on it, Judge Simpson. But SOS doesn't stop. She said that I already filled the paperwork out yesterday when she came. They pay August, but after August, I won't be getting no more help from SOS. But I reached out to Hawk. They're able to help, and I did do an SCR with my caseworker, and I have an appointment with my caseworker on Monday for help, so I can get help with my rent, and I'm able to pay.
This is where the human side of the courtroom comes into play. Fleming just revealed she's been unemployed, just landed a new job, and scraped together $900 to show good faith. But is that enough against a $4,200 debt? Legally speaking, partial payments don't stop eviction unless the court accepts a redemption plan. Emotionally, though, this shows she's trying. Do you think $900 should buy her more time? Or is the landlord right to demand full payment?
Altogether, $900 today, but that's all I can afford.
if we get to August 1st, then August rent is gonna kick in, which means you're not gonna be.
No, August rent is paid by her, by SOS.
I'm gonna let you finish because I'm not gonna be interrupted again.
I'm sorry.
So what else did you want to say?
That's all I had to say. That's what I said. It was already paid. August month is already paid. That's why she came over yesterday and I filled out the paperwork. So August month to be paid. After August, September, I won't be getting no help after August, is what I'm telling you.
If SOS pays in August what they paid in July, it would be $650 on a $1,300 apartment, which would mean she'd be responsible for the other $650.
That's not true.
But even without, let's assume that for the sake of argument that SOS is going to pay the whole thing. She still has a $4,200 balance. And I don't think there's any way that's going to be paid. And she hasn't filed the form, even though, you know, the previous person heard you just fine last week when you said, we get it here within 5 days. It wasn't here within 5 days. We'd ask for a judgment today.
I did turn it in within 5 days. You said turn it in Wednesday, which I did turn it in Wednesday. And who is he to say that I won't have all of it paid? Like, you don't know that. I didn't know I can get as much help as I did until I reached out to all these companies. And I was unemployed for a while, which I just got a job. I just started working 3 weeks ago. So this is my first check. You have to wait 2 weeks in a hole to even get your first check.
Your Honor, I'm willing to extend the judgment, normally be the 28th. If we were to extend the judgment to August 4th.
There's no tribal issue for this court in regard to this case. I'll grant a judgment court possession.
And there it is, the ruling. The judge issues a strict deadline. Pay $4,998.39 by August 4th, or risk losing possession. Notice the precision here. The court isn't factoring in future rent disputes, only the existing balance. That's actually a small break for Fleming, because any August confusion won't pile on. But let's be real. Raising over $4,000 in less than 2 weeks, that's nearly impossible without outside help. Think about it. If you were in this situation, how would you come up with that much money so fast?
With the redemption amount of the $4,298.39, with a writ to issue August 4th, 2025. Thank you.
Can you tell me exactly what does that mean?
I just issued a judgment, the 429839 will need to be paid on or before August 4th of 2025. I've done it that way because if I grant an adjournment in this case, quite frankly, whatever the dispute is with the August rent would be added on to this figure, which I was trying to say earlier.
Yeah.
So it's a benefit that if you can find the funds to get this paid, you only have to pay this amount. Does not include anything for August.
Okay.
Right.
Well,
So you have to the 4th to get it paid.
Yeah, but last thing I gotta say is that when I talked to my SOS worker, Miss Terry, our agreement was for her to pay the full amount because she know I'm not gonna be able to pay the full amount. The money that I have now is going to be towards to the money I already owe. So August is already gonna be paid. Like the full amount is gonna be paid, so I won't have to worry about August.
Maybe you're not hearing me.
I'm hearing what you said.
The judgment, I'm not dealing with August.
I know that. I'm just let you know for sure that's gonna be paid. That's all. But thank you. Have a nice one.
Thank you.
Jesus. People in the room.
Won't stop.
Nope, doesn't work.
So let's wrap this up. PF16 LLC wins their case with a judgment of $4,298.39 against Keir Fleming, due in full by August 4th, 2025. The judge drew a hard line. Show respect in the courtroom. Follow deadlines and pay up or risk eviction. This case highlights the tightrope between legal obligations and real-life hardship. On one side, landlords need stability. On the other, tenants facing job loss and limited resources are fighting to stay afloat. Now, what do you think? Was this judgment fair, or should the court have given Fleming more breathing room? Drop your thoughts in the comments. And if you found this breakdown as shocking as we did, Make sure to hit that like button, share this video with your friends, and subscribe for more jaw-dropping courtroom drama and legal breakdowns. Until next time, stay tuned, stay sharp, and stay informed.
Oh.